Hey everyone, it's Enoch again, learning with the senses, and we are here again for a commercial transaction, and this is the third module. I've come to disturb you again with sale of goods. It's a very broad topic, and now we are entering into terms. We're entering into terms, the terms of the contract. We started by giving a general consideration of what are terms, conditions, warranties, and co. But now we're going to go into the specific provisions of the statute of the Sale of Goods Act of 1893. We're going to start listing out specific sections and co. So please try and join me as I do that. Just want to take note that there are a lot of sections and there are a lot of principles, but I'm going to try as much as possible to compress them. And I also like to note that you actually have to look into this section. It's not just enough to just watch this video alone. This video is a great starting place, but like they say, journey of 1,000 miles begins with a step. You can't just take the step and say you've gone on the journey. So take this step, but please continue on. Section 10 of the Sale of Goods Act of 1893, stipulations as to time. It says that generally stipulations as to time are not of essence in a contract of sale. That generally stipulations as to time are not of essence in a contract of sale. But this is when it pertains to payment, I believe, payment. Except a different intention appears from the terms of the contract. It gives a general proviso, but then goes on to say again that, that this could also change depending on the intention of the parties. That generally stipulations as to time of payment are not of essence in a contract of sale. Take note, I said stipulations as to time of payment. In the previous module, I mentioned that as long as there's been an intention of the parties for property to pass, even though you've not paid, it's still a legally binding contract and agreement of sale. So, generally stipulations as to time of payment are not of essence in a contract of sale, except, like I said, there are exceptions and there are exceptions to the exceptions, except a different intention appears from the terms of the contract. So if in the contract itself it is stipulated that, if you do not pay at this particular time, then we don't have a contract anymore. If you actually don't pay at that particular time, then you don't have a contract anymore. You can't come and claim under Section 10 because Section 10 gave an exception that except as intention appears from the terms of the contract. And it also goes on to say that whether any other stipulations as to time in the contract, this is apart from payments, any other stipulations as to time, maybe like delivery and co, depends on the terms of the contract. Like I said, sale of goods, something that happens every day, something that depends on the parties, on the intention of the parties. So if they show in the terms of contract that stipulations as to time are important, time of delivery, because some goods are very time sensitive and co, so it will be important. Depends on them. And there are cases to illustrate this. One of them is the case of Becquerel Demo versus Colgate Palm Olive Nigeria Limited. Let me say that again. Becquerel Demo and Colgate Palm Olive Nigeria Limited. Some of these cases are a mouthful. Very hard to say, like a tongue twister. But it was held in that case, in that scenario, that they had made time of payment a condition of the contract. So what happened in that case was that they had an agreement, and in their agreement it was stated that that delivery will not be made beyond 30 days, and in that time payment also will be made and everything. And so the court held that in that kind of situation, payment was a condition of the contract. And now I move on to implied terms. Like I said, implied terms is one of the things that the aspect of terms, when we were talking about terms of contract in sale of goods, under the Sale of Goods Act, implied terms is something that the statute focuses a lot on. So the reason is that one of the main aims that the Act, SOGA, Sale of Goods Act, aims to actually tackle is the problems that came before it. See, before SOGA, little protection was given to the buyer. There was little protection given to the buyer because the attitude of the law was caveat emptor. Caveat emptor in quotes. This is a Latin word. There are some places now, properties, and so you will see, you write it on the wall and go, caveat emptor. It basically means buyer beware. That whatever you buy at your own risk, or whatever. That was like the state of the law of sale of goods before the Sale of Goods Act. That, if they run you streets, they run you streets, and there's nothing you can do about it. That you were meant to beware. See, but now SOGA has implied some terms into every contract of sale automatically by law. That even if you don't mention some of these terms, it's already implied into the contract. It's already there by law. And these are found in section 12 to section 15 of the Sale of Goods Act, SOGA. These are found in section 12 to section 15. And so I'll be running through them one after the next. Like I said, sale of goods is something that is very statute-based. There are cases, yes, I'll be mentioning cases, but they all must stem from their statutes that come with them. So the first one is the implied condition as to title. And this is governed under section 12 sub 1, the implied condition as to title. That there is an implied condition that the seller has the right to sell in case of a sale. You know, when we're given the definition of sale of goods in section 1 sub 1 of the Sale of Goods Act, we identify the elements that there's a seller, there's a buyer, there's a consideration, there's a transfer of property, and there's a distinction between a contract of sale and an agreement to sell. Now, we're about to get to why it was important to make those distinctions. And this is how they come up with problem questions and questions that trip people up. Because most of the time, people think that these distinctions are not important, but if you actually catch them well, you'll be able to navigate. So, section 12 sub 1, implied condition as to title. That the seller has the right to sell in case of a contract of sale. That if we're selling it immediately, that yes, that you must have had the right or the title to sell it to me. That you must be the owner, you must have had the consent of the owner to sell to me. And that in the case of an agreement to sell, like we said, that is the situation where the sale is going to take place at a later time, or maybe because of the fulfillment of some terms that are about to be fulfilled. Cool. That at the time of the agreement to sell, that it would have the right to sell the property when the property is meant to pass. That when the property is meant to pass from the seller to the buyer, that the seller would have had the title to sell by then. Because you can't sell me what you don't have. You can't give me what you don't have. That's another principle under, there's a Latin term for that, nemo dat quod non habet. Nemo dat quod non habet. You can't give what you don't have, basically. We're still coming to that in passing of property. Passing of property, don't worry. We're here for you. We're here for you. We're here together. Okay, there's a case under this topic, and the case is Niblet versus Confectioners Materials Co. Niblet versus Confectioners Materials Co. In that case, what happened was that the manufacturers, they manufactured some things, and then the labels that they kept on those things were labels that were very similar to a very well-known brand. So, and they sold those products. And then the court held that there were some issues that they could not discharge them from the warehouse and co. And then the court held that that the sellers had no title, because seeing as the labels on the goods were not their property, how could you now sell something that's not your property to someone else? They held that the sellers were in breach of the section 12 subsection 1 as a result of labeling. That there was a breach of that implied condition. Remember, please take note of the words I'm saying. When I use condition, when I use warranty, I gave the importance of the distinction, because they both have different legal consequences, as we said in the previous module. Please follow the modules, follow it back to back, bumper to bumper, because it's a continuation. Sale of goods is a long topic. So if you miss one, peradventure, you might not be able to get the context of the next one. So please just try. Implied condition to title is very important, because if it is breached, then you as a buyer, you are entitled to reject the goods and terminate the contract. Yes, you are entitled to reject the goods and terminate the contract, because it goes down to the very depths of the contract. I want to get something from you, but yet you are not the owner of that thing. Worse still, you don't have the authority to sell that thing to me. Therefore, if I buy something from you under those conditions, that means I actually acquire no property in that thing. That means I'm just giving you free money, because when the true owner comes calling, they run me streets in the end. Okay. In the case of Roland and Duval and Akoshile and Ogidon, it was held in both cases that Section 12 Sub 1 was breached, thereby causing a failure of consideration. See, those cases involve the sale of a car. You know, this country, there are many things that have to happen. And you know there are situations like this where maybe a car is stolen and they go and sell the car again, and then something, and Wahala starts to be like bicycle. That's what happened in these two cases. Like a car was stolen and then it was resold and to an innocent buyer and purchaser. It was held in that situation that Section 12 Sub 1 was breached because the seller had no title. Because there's a failure of consideration. Like we said, consideration is the value you are giving in exchange. I want to give you money in exchange for the car, but you are not the owner of the car, therefore you cannot validly transfer it to me. Therefore, there is a failure of consideration. Therefore, they have breached Section 12 Sub 1. Implied condition as to title. Very important. That's why it's a condition. Now, the next one is warranty as to quiet possession. Like I said, differences. There are important differences. The other one was a condition. This is a warranty. This is a warranty. Warranty as to quiet possession. This is governed under Section 12 Sub 2. That there is the implied warranty that the buyer shall have and enjoy quiet possession of the goods bought by him. That he shall have and enjoy quiet possession of the goods bought by him. Meaning that under no circumstances should there be an interference with the goods, maybe by a third party or even by the seller himself. And when I say interference, I mean lawful interference. How could I buy something from you, and then the next thing I hear is that, oh, this third party is coming, that he has a legal claim on that property, or that you too, you will come again and say that, oh, can it come happen to the property? And then, no, it's not meant to be like that. There is an implied warranty as to quiet possession, that since I bought it from you, I should then be able to enjoy it the way I want it, how I want it. That there should be no scenario in which a third party can then come to lawfully interfere with my right to enjoy it. It is not possible for the law to prevent unlawful interference. That's a different thing on its own. Like now, someone can just unlawfully interfere with your possession of something. But then it's saying that there should be no situation in which someone can lawfully, in the sense that the person can assert a legal right over something that you consider yours. So in Udeku and Abosi, I hope I'm not offending with the names, because some names are strange to pronounce. It said that in that case it was held that this warranty is available, but it does not cover disturbances by officials who wrongly interfere with the goods or against trespassers. Like I said before, there's a slight distinction. It covers situations where, there was a legal interference, meaning that no one should have a legal right to interfere with something that you bought. Yes. But it does not cover situations where there is an unlawful interference. Where there is an unlawful interference by officials, or where there is an unlawful interference by a trespasser. There's nothing much that the law can actually do about that. But you should note that this warranty is a continuing obligation. Unlike that implied condition to title that we mentioned then, the moment that one is important is at the time of sale. At the time of sale, or at the time when property is to pass. But this one is a continuing obligation that applies even after title has passed. Like I said before, the condition as to title, that one just applies at the time when property is meant to pass. In the case of Microbeats AC versus Vimhurst Road Markings Limited, Microbeats AC and Vimhurst Road Markings Limited, it is important for us to go through these authorities, because law is governed by authorities. You know how important authorities are in a law exam. You have to take note of them. And the earlier you do, the better. If by the time you start taking note of them now, they'll be easier to recall when you read the facts, when you read the judgments or summaries. Okay, in that case, it was held that there was a breach of warranty to quiet possession when a person had been allowed to acquire a patent in respect of goods that had already been sold to the buyer. Imagine, you've already sold something to me, and then you sold the patent of those goods to someone else. It's funny. It's a funny scenario. It's a funny scenario. You know what the patent is? That it's like trying to protect your intellectual property. Cool. So you have already sold the property to me, yet you are giving the patent to someone else. The meaning that the person can interfere with my possession of those things that I've already gotten from you. It doesn't make any sense. So in that scenario, it was held that there was a breach of the warranty to quiet possession. So now the third one we're going to consider is freedom from encumbrance. Freedom from encumbrances. That's governed by section 12 sub 3. Freedom from encumbrances, section 12 sub 3 of the Sale of Goods Act of 1893. There's an implied warranty that goods should be free from any charge or encumbrance in favor of any third party not declared or known to the buyer. Meaning that in the sale of goods contract, if there is any encumbrance on the goods or property by whatsoever means, as long as the seller knows about it, he should disclose it. That if it is not disclosed, then there is a breach of this place. Freedom from encumbrance, section 12 sub 3. If it's not disclosed, then there is a breach of this. Let me give you a scenario now. Like there are some parts where they sell, like let's say whether they are selling whether they are selling a phone now, and we know that the phone had to go through some repairs, and maybe they've not finished paying the repairman finish, and they decide to sell the phone to you, and that's how the repairman will catch the phone in your hand one day and start to say, oh, I was not paid for the repairs done on this, so. That is an encumbrance in favor of a third party, and it has not been declared or known to the buyer. So what that section stipulates is that it must be declared to the buyer. That is if the seller knows. But if the seller is unaware, you can't claim under